Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I'm right here on this station every Sunday from 8 to 9 a.m. to bring you, the landowner, the oil and gas right owner, the information that you need regarding natural gas development here in Pennsylvania. And let's give everyone the weekly reminder that I, Doug Clark, at the Clark Law Firm, do not, have not, and will not ever represent oil, gas, or pipeline companies. Haven't done it, will not do it. I represent landowners, royalty owners, oil and gas right owners for such items as lease negotiations, done many of those, pipeline agreements, easily have exceeded working on files, negotiating, reviewing pipeline contracts with over 60 different companies in Pennsylvania, giving you the idea of what's out there, and represent people all across Pennsylvania in any area in Pennsylvania related to any type of oil and gas issue, royalty issues. We talk a lot about royalties, deductions. We talk about unitization issues, well site, well pad, any contract. We say this all the time. If you have a contract, you're asked to sign anything, get help. Whether you call us, call somebody who knows what they're doing. Just this past week, client asked to sign a map. I talked about beware of maps. Don't just sign or initial maps. This person presented a map, didn't sign, smartly gave us a call. We looked at everything and said, hey, you don't need to do this. And we negotiated, and the net result went from a very low number up to a pretty high number. And there's one thing, it's not like it goes from 500,000, say, to 585,000, which is a lot of money. However, that was a major increase, but still you were up there very high. In this particular case, the original offer was below $20,000, and the final offer is above $100,000, or the final agreement is above $100,000. So, in this particular case, not saying it always happens by any means. Sometimes it can go even higher, sometimes lower, sometimes nothing. But in this particular case, a phone call and probably maybe $1,000 in legal fees results in a $90,000 increase for the landowner. $90,000 increase. I hope people are hearing that. I am not saying that happens all the time, but I will tell you, it sure as heck can't happen if you don't try or if you don't find out. And in this case, relatively easy because we are able to assess the leverage, make our determinations, and say, hey, wait a second, you don't have to do this. And the end result, an extra $90,000 versus just signing the map and not getting any additional money. Most people will take the $90,000. Similarly, I tell this story, kills me. It's like, going on vacation is always tough because when you go on vacation, you got to work your butt off leading into it to try to prepare yourself. And then when you come out of vacation, well, you've been away, so the work piles up and you have a lot of work to do to come out of the vacation. But there's another issue. I'm going to tell you, I'm not going to stop taking vacations. I work very hard. That's my time away to, recharge the batteries, as they say. But in this one case, I go away on vacation. Landowner sends an email, says, hey, they came and they approached me with this map. And by the time I get to this email and see it, and again, I'm on vacation, send them say, hey, listen, don't do anything. I'll be back next week. And I come back, and sure enough, the landowner, unfortunately, didn't wait for me to come back, signed the map, and agreed to a very lengthy new roadway going across their property, not where they want a roadway on their property, for no additional money because they just signed the map. and they couldn't wait the extra 5 days for me to come back and we could talk about it and assess what their options are. So the person received no additional compensation, approved a major roadway on their property that they didn't have to approve, or they could have negotiated for more money, and the company gets assigned map, see you later, and now they're going to install a roadway where they had no right to do it before and where the landowner doesn't want it. So what do? We don't just go signing documents when they're presented to us. We don't just go signing maps. Oh yeah, here, just sign this map, we'll replace the other one. We don't do that because we know that this may be an opportunity. Because if the company doesn't have the right to do it, you have the right to negotiate. That's your deal. Because again, if the company has the right to do it, they're not going to come to you. They are not going to come to you. It's one of these things where we have to get out of the mentality. And this is the nature of the world. When you enter into an agreement with a gas or a pipeline company, and they're allowed to do something under that agreement, they may come to you and say, hey, here's what we're going to do under this agreement. Put a pad in, put a pipeline, put a roadway. Landowner says, oh gosh, I don't want that. And maybe they say even more aggressively, instead of, oh gosh, they say, I don't want that. I'm not going to agree. Company then says, well, Mr. Landowner, you signed a lease. You signed a pipeline right-of-way. We have those rights. That's what we paid for. And you as a landowner, you look at your lease and you say, okay, I guess maybe they do. Now, if they ask you to sign something, maybe they don't have the right to do it. Signing any document whatsoever better raise red flags for you, the landowner. If you are asked to sign a document, knock on a door out of the blue, hey, we need you to sign this map. We want you to sign this document. Oh, because if you do, we're going to get you money real quick, or we're going to get you royalties, or we have the right to do this anyway. Don't sign that. Look, not specific advice, but very general advice. Do not sign that document. Do not sign that map. Pick up the phone, get an appointment, get a review and consultation, get information, and learn your rights. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're here with you every week from 8 to 9 a.m. right here in this station. You can contact the office 570-307-0702. So, okay, I want to just, I can see I'm going to spend this first segment in this topic, which wasn't my plan, as often is the case. My plans go awry. But seriously, this is a big issue. It is a big issue because within the last, like I say, week and a half, from beginning to end, in a matter of a week, this landowner is going to make $90,000 more and is going to get a legal fee around $1,000 total. And it's because they didn't just sign the document. And this happens so many times. And it's funny because I sit there, I laugh to myself. I'm like, well, yeah, okay, company, you got the one landowner. I was away on vacation, and unfortunately, the landowner fell for the hurry, which again, don't fall for the hurry. The company doesn't sit there and say, oh, geez, we better go get this today. We need it tomorrow. That's not how it works. They go at times years in advance. They come to you with 5-year options, which means that after you sign, they have 5 years to decide what they want to do. But then you as a landowner are told, hey, we want to hurry up and do this. Well, if you want to construct this pipeline, roadway, major pipeline is a great example, though. If you want to do that in 2017, maybe even 2018, well, that's what? 1 or 2 years? We can do that math. So if you want to do something in 1 or 2 years, why in the heck do you need a 5-year option? Why do you need a 3-year option? If you're going to do this in 2017, how about we give you a 15-month option, which will give you more than enough time. We can't do that. We can't do that. Well, in other words, you're not doing this next year. You can't commit to doing this next year. But yeah, it sounds great. Oh, we want to do this. We want to get you money. Here's a pen. Here's money in the future. Well, if you're handing me money right now, maybe that makes it more attractive. But a promise of potential future money, be careful. We've heard that before. But more importantly, you need to understand that these can be incredible opportunities. And they can be many times. They're opportunities to get out from under bad oil and gas leases or bad pipeline agreements or other right-of-way agreements that you may have entered into without the knowledge that we have today or without the assistance of an attorney. And so if you have an agreement and some company wants to amend that agreement, amend the lease, amend the pipeline agreement, give you a new map, don't sign, pick up the phone. Call me or somebody else, but learn about your rights. You really need to do this because when you're asked to sign a map, they need something from you. They need that map from you. Now, in some cases, you may say, okay, hey, yeah, this isn't a big deal. I'll go ahead and do it. But I'm telling you, in many cases I see that when you're requested to sign a map or to sign an amendment or a modification, it presents a great opportunity. And also, the great thing for you is, generally speaking, you get a map, you get an amendment, I can look at that, and within the time of less than 2 hours, by the time I study everything and we conclude either an in-office visit or a conference call, we can tell you, hey, here's what all your rights are. Here's a plan. Here's some different options. How do you want to proceed? I say all the time, I don't make decisions for the landowner client. They make the decisions, but my job is to give you, the landowner client, all the information I can that you need to allow you to make the right decision. And I am going to give you, and your attorney should give you, the information from your side, the good, the bad, and all the information that you can get. So the more your attorney knows about whatever the matter is, oil and gas lease, pipeline, whatever, they're going to be able to assist you more. If it's the first time they've seen something or they don't see these all the time, well, they're not going to be able to assist you as much as somebody that sees these all the time. So again, not to be a commercial for me, but we do this all the time. So we can assess the leverage, give you your options, and within an hour or two, you can have a really good idea. Okay, here's what my options are. Or not even a good idea. No. Hey, here's what the rights are of myself. Here's what the rights are of the company. Here's what's going on here. How do I want to proceed? And like this other example, the gentleman makes this call, we do this, and within an hour, in that case, we determine, hey, this is a really good opportunity here. And as a result, the payment is going to increase by $90,000. So from a very small payment, a relatively small payment, to a six-figure plus payment. So I shouldn't say six-figure payment, not six-figure plus, but six-figure, not seven-figure, six-figure. So again, that's an opportunity that for a relatively small investment generated a substantial income. And while we're talking about that, let me be clear. I do not, so you know, and I have problems with people who do, but I never, ever have taken a percentage of any landowner's like pipeline payment or increase in payment. So if you're offered $20,000 and you sign for $100,000, so you have an $80,000 increase, I don't get any percentage of that. I don't want a percentage of that. That's your money. That's your property. I do my work on an hourly basis as a general rule. 95+% of the work I do is on an hourly basis. So if we get you $100,000, but it only took us, 5 hours to do it, you get billed for 5 hours. You don't get charged 30% of $100,000 or $30,000. You don't get charged 20%, no percentages. So my opinion, I don't like I won't charge percentages because I don't think it's appropriate. I don't think it's fair to the client landowner. So just if you're ever thinking that or you have any reservations, just know that. And be careful. If your lawyer is charging, they don't like me, but if the lawyer is charging percentages, think about that. Think about that. I have some issues with that personally, and I think maybe you need to think about that more if that's your situation. Okay, we're going to wrap it up here for this segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here with you every Sunday, 8 to 9 a.m. on this station. You can call us, learn about what we do, see if we can help you. 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, the guy who does not, will not, and has not, and will not represent oil and gas companies. And real quick for my northeastern Pennsylvania guys, there's some more pipeline routes coming on, and we're getting more and more calls for that. So really encourage you, if you get a new pipeline agreement or proposal, put the documents down, pick up the phone, get at least a review and consultation early, learn your rights. Please do not agree to anything. That would be my general advice, not specific advice, but general advice. Please just put the document down and get some assistance. The company wants you to rush. We want you to be informed and take your time. Okay, I'm going to switch gears now. But before I leave, if you're given a document and you're asked to sign and they want to hurry up, put the document down. Pick up the phone. Get the information. Don't agree to anything. Pick up the phone. Have a review consultation, whether it's me or somebody else. Pick up the phone. We got to get people informed. The call can be an amazing difference. I just happens all the time. Do not sign agreements. This is general advice for everybody without getting assistance. All right. Sorry. I have to do that sometimes. Okay. So here we go. Sometimes we have some ranting sessions where I just rant because things make me upset that I see what I believe people being taken advantage of because they're uninformed, and that makes me crazy because I envision my parents and my grandparents, and I know the landowners in Pennsylvania, and they don't deserve to be taken advantage of. Nobody does, but certainly not these people. So we need to get that information out there. So I get fired up sometimes. So I'm going to talk about, and then sometimes we do things that are a little more technical. And I'm about to get a little more technical. So we encourage people, stick with me. I'm going to it's going to be a little technical, but we're going to give some explanations. But remember, you can go on Monday morning to the websites, our websites at pagasleaseattorney.com, pagasleaseattorney.com, pipelineattorney.com. Go there anyway. But go there. You can check out today's show and all these other shows, not all of them, but gosh, there's a lot of them up there. You can go and listen to prior shows on pagasleaseattorney.com, pipelineattorney.com. So like a show like what I'm about to get into that gets kind of technical, you're not going to probably pick everything up. You're going to get some big points here, but you're not going to pick everything up. So you can go back and you can listen again. And of course, if you can't make the show, when it's on or when we do the show each weekend, you can go anytime during the week, anytime, day, morning, noon, night, anytime, and go listen to the shows. And if you're new to the show, look, pagasleaseattorney.com, pipelineattorney.com, go check out prior shows. I've been doing the show since 2010. Been doing All Things Marcellus since 2010. And I'm not stopping. We're not stopping. All right, so here we go. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and we're going to get a little technical, which requires me to put on my glasses, which I'm still trying to adjust to. All right, so I've talked about this recently, but we're going to hit it even more because it's so important, and it's a super hot topic at this time. Very, very important, and it is the oil and gas conservation law. The oil and gas conservation law. So what in the world? Here he goes. What's he talking about? Well, all right. The oil and gas conservation law is a Pennsylvania law that applies to oil and gas development. That's pretty shocking. Oil and gas conservation law, maybe it deals with oil and gas. Well, it does. It does. But there's a lot more than that. So why is this oil and gas law? Why are we talking about it? I've never heard of this. You're out there I never heard of this, because nobody wants you to know this. The companies do not want the Pennsylvania landowners to know this. Again, I'm about to talk to you about something very, very important that I guarantee you that the companies, oil and gas producing companies in Pennsylvania, do not want you to know what I'm about to tell you. That's just the flat out truth. That's the flat out truth. And I'm going to tell you something too, that I would bet, this is just on my educated experience in dealing with people, that virtually no landmen out there know about the oil and gas conservation law and how it operates. In fact, most lawyers do not either. But for those who do, I'll tell you this, they're not talking about it either, because they don't want the landowner to know what I am about to tell you. You're listening to All Things Marcellus with me, Attorney Doug Clark. So here we go. I hope that is a good lead up. So hopefully your ears are perked and you're paying attention. So the oil and gas conservation law. Well, what's important about this? Well, here's the deal. It is unique because it only applies to geographic formations, meaning rock layers, like say as an example, the Marcellus Shale is a formation. The Utica Shale is a formation, geological formation. So the oil and gas conservation law is a unique monster because it only applies to wells drilled that penetrate the Onondaga formation or deeper horizons, okay? So, or a depth of 3,800 feet. Now, what we really need to focus, again, we're going to try to make this easy to follow, so let's just think of it mostly as, because what's relevant for our conversation is that the oil and gas conservation law applies to wells that penetrate the Onondaga formation, and for our purposes, what that means is this: the Utica Shale formation is deeper than the Onondaga formation. So if the company is going to drill down to the Utica, they're going to penetrate or go through the Onondaga formation, which is above. You have the surface of the earth. You drill down, you'll run into the Onondaga formation, and below that is the Utica formation. Above Onondaga, above is the Marcellus formation. So again, make this easy to follow. Company starts drilling from the surface of the earth. For our purposes, we say they're drilling down towards the center of the earth, and they hit the Marcellus Shale formation. Then they'll hit below that the Onondaga formation, and below the Onondaga is the Utica formation. So the oil and gas conservation law, holding a copy here, it only applies below Onondaga, so it applies to Utica, one of the formations. But as you know, the Marcellus is above the Onondaga, so this oil and gas conservation law does not apply to Marcellus. Does apply to Utica, but not Marcellus. Very, very, very important. Why is it important? Because people know that if a company is going to develop the Marcellus Shale formation, and the company is going to drill a horizontal well, and they're going to create a production unit. So they're going to produce gas from this designated area. They define an area, and they say, here, we're going to create a unit, and we're going to produce gas from this unit. In the Marcellus formation, if you are a landowner and your property is located physically within the unit that the company creates. And that means like on a map, they create a unit and they say, here's where we're going to drill. Here's where we're going to extract gas. And they say that's a unit of 1,000 acres. And I'm picking that number. Don't get fixed on the number. So, but for example, 1,000-acre unit. There are going to be a lot of property owners that have property in this 1,000-acre area. So say there's 20 people. Well, under the law that applies to the Marcellus Shale Formation, if you have property that's located in this 1,000-acre designated area of production and you are not under lease, your property can physically be located within that 1,000-acre designated area. So say you had 10 acres and it's right somewhere in the middle of this 1,000-acre production unit that has been designated. If you don't lease and the company does not drill underneath you, well, you're not going to get any royalties, even though you're square in this designated unit. But the other side is, if you're not under lease, the company in the Marcellus Shale Formation cannot drill underneath you. Now, the problem that sometimes arises is if you hold out and I want to go down this path, we're going to talk about, this is a formation discussion, but if you didn't sign and now this unit is formed and you keep using 10 acres, well, as long as the company doesn't drill beneath you, which they're not allowed to do, if you don't sign, they can't legally drill underneath your property. That would be a trespass, and that would be a violation, okay, of Pennsylvania law. So they're not allowed to drill underneath you, but they don't need you to sign. They'd like for you to sign typically, but they don't need you to sign because they're not going to drill underneath you. They're going to drill around you, so they don't need you to sign. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you every Sunday, 8 to 9 a.m. right here in this station. Okay, let's do a slight reset here. We're talking about if a company creates a production unit for Marcellus Shale production and you are not leased, you didn't sign a lease, the company can go ahead and create that unit. And as long as they do not drill underneath you, which they are not allowed to legally do, that would be a trespass. They can drill around you. So you could be located, your property, if you look at a map, your 10 acres could be within this 1,000-acre unit, in my example, and you're not signed, and you're sitting square right in that unit. You, because you're not signed, will not get any royalties from those wells in the Marcellus Formation, even though your property is located within the unit. That seems, sometimes that's troubling for people, but that's true. The other thing, though, is if you're not signed, the company cannot drill underneath your property. And that can give people, in certain cases, a lot of leverage because your property could be positioned where it's going to prevent a company from drilling a well that they want to drill, and it might prevent them from drilling multiple wells that they want to drill. This isn't advice on anything. When you're in this situation, you need specific advice because people overplay their leverage at times and people underplay their leverage. So that's, again, I talk so much about leverage because I think it's one of the most important, if not the most important thing when you're dealing with these issues. You need to appropriately assess your leverage. So, okay, we're gonna do one quick more little setup, and then we're gonna take a break, and we're gonna talk Utica in a minute. Then, so okay, again, we're talking Marcellus Shale, 10 acres. You're a 10-acre property owner. Your property could be physically located within a production unit, and if you didn't sign royalties, 2 rules I want you to know. Number 1, company can't drill that lateral well underneath your property. Can't do it. That would be a trespass. Number 2. You could be physically located in that unit, but you will never receive a royalty check if you're not under lease with one of the companies that's involved in production of gas. So the companies have some leverage to say, well, hey, at the end of the day, and look, again, I don't want to go down this path about when do you sign, when do you don't sign. But at the end of the day, I have a client literally right now. Gas is starting to be produced, and we're working on doing a lease now, and because they're going to form the unit, and we're going to get it done as gas is getting produced literally now. So you can at times wait till literally production starts, despite what people say. Okay. So again, though, sorry about that, but it is important. Marcellus Shell, you could be in there. Company says, hey, we don't need you. We don't need you. We will form the unit around you and not drill under your property. The company can say that, and that is true with the Marcellus Shale formation. However, that is not true when we're talking about Utica formation. And that, ladies and gentlemen, is what we're going to talk about after this break. So if you are in an area where a company wants to develop Utica shale, you may have some additional leverage. Like the gentleman I just did a lease review and consultation with last week, who had 2 acres, and his offer for 2 acres that they were not going to drill underneath, no intention to drill underneath this property, 2 acres. They offered him $3,500 an acre and 18% royalty for 2 acres because they wanted to develop, or they want to develop, his 2 acres in the Utica formation. And they can't say to him, well, if you don't sign, we'll just go around you. They can't do that. And that's why he's offered $3,518%. So if you're in an area of Utica shale development, you need to know this. I'm going to get into it more after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You know, it's a bit of a complicated show, so check out pagasleaseattorney.com, pipelineattorney.com. If you have any agreement in front of you, before you sign, give us a buzz, learn at least about the reviews and consultations, doing so many of them, and they are going so well for people. They really, really are. Give us a call, see if it's right for you, regardless of your location. 570-307-0702. We truly want to help every person we can. Everyone. Give us a buzz. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, with you every Sunday, 8 to 9 a.m. Give us a buzz. Learn about reviews, consultations. 570-307-0702. So, okay, let's get back into this. Again, I don't know where else you're going to hear this. So tell your friends, go back to the websites, listen to this show. We need to know about the oil and gas conservation law. We need you as landowners to know. Whether you ever call us, I want you to know about the oil and gas conservation law. Not sure who else out there is talking to you about it, but you need to know the oil and gas conservation law. You don't need to memorize it. You need to know these big points. Because if you are in an area of Utica shale development, for example, Tioga County, other counties as well, but if you are in an oil and gas development area where Utica shale was a targeted formation, you may have way more leverage to negotiate than you ever imagined. Especially, well, it doesn't, I'm going to retract the word especially. But even if you have, like the one gentleman I talked about who had 2 acres, and his 2 acres were going to be in 2 separate units, meaning that they were at the absolute edge of the units, meaning there was never going to be a well drilled beneath this property, not even actually very close to this property, but the company still is offering $3,500 per acre to lease this property and offering 18% royalty and guaranteeing that they would never go onto the surface of this property, but just include it into this unit. And why were they doing that? Well, because they wanted to drill Utica shale wells. And because Utica shale wells fall under the Oil and Gas Conservation Act. But if you as a company have all the landowners under lease within the unit that you're going to go ahead and develop, it is much, much easier. Because if you don't have all the properties under lease and you're going to drill a well that's going to extract gas from a property that you don't have a lease for, well, you may have a problem. And the problem is you may have to go through quite the process in order to drill that well that you want to drill. And it's such a process that to date, not one company has gone through the process. They haven't gone through it, and they don't want to. Believe me, they don't want to, or they would have already done it. They don't want to. It's expensive. It's difficult. There are appeal rights. There's a long process to this, and it's unknown. It's unknown. So they want to lease you. They want to lease you. I was joking. I would never do it, but the idea of, look, there's something to be said by a bunch of, and not advising anyone to do this, but if you owned a quarter-acre piece of property all over the place, a whole bunch of them in areas of Utica shale development scattered all over, you might have some very interesting leverage. So not advocating anyone do that, but it's interesting. So this guy, again, to show you the impact of this gentleman has a 2-acre parcel that is all the way at the end of units, meaning that he's not blocking anybody. He's not, because of the way his property is situated. The company, it's not like they want to drill underneath him, so they want to get his permission because otherwise they can't drill directly underneath his property. That's not what's happening here. They're not going to drill underneath him. But he's within this, I'll call it, zone of extraction for this well in the Utica formation. So they need to either lease him or go through this very complicated process and have the state or the Commonwealth of Pennsylvania issue a ruling which forces that 2-acre landowner into this unit, even though the landowner didn't sign a lease. You say, what, this guy, I think he's now off his rocker. Sound like he was talking about forced pooling. And I know, I read a lot, I follow on the internet, there's no forced pooling in Pennsylvania. Well, maybe there isn't, but actually maybe there is. And what I mean by that is that in the Utica shale formation, if you are not under lease, there is a legal process. The Oil and Gas Conservation Law sets forth the legal process of how a gas company can take a property, and they approach, and there's a lot of process to this, but they go through a process with the Commonwealth of Pennsylvania, go through a process that if you are a landowner, and let's use my example of the 10-acre landowner who in a Marcellus shale unit didn't sign a lease, and the company says, well, okay, we just can't drill underneath you, we'll just go around you. In the Utica shale formation, if that landowner is in this zone of extraction for this well, that's a problem for the company. And if they can't lease you, they're going to have to go through this process set forth in the Oil and Gas Conservation Law. And no company wants to do that. They want to lease you. So that may give you some additional leverage. That can take my example, hypothetical example, the 10-acre landowner in Marcellus shale formation can easily be cut out of the unit by just simply not drilling underneath them. The 10-acre landowner, or 2 acres, or whatever acre we want to pick, who a company wants to develop in Utica Shale, not so easy. Not so easy. So the companies in areas where Utica Shale development is going on or anticipated, and think Tioga, think Western Pennsylvania, those areas, the company really wants to lease you so they never have to deal with these requirements of the oil and gas conservation law. So if you're one of the many landowners who the company went and drilled a vertical well down to the Marcellus formation only, solely to hold your lease and not let that lease expire, solely to do that, solely for their benefit, to hold you under lease and not to let you renegotiate your lease for better terms. They drill a vertical well down to the Marcellus Shale formation. Well, Tioga County people, a lot of you guys got very lucky, thankfully. Very excited about that. Very happy for you. Very, very happy for you. You got a bad deal because the company just drilled a vertical well to hold you, and there's been no production, and they just keep paying you shut-in many examples. That's not a good deal for you. Not yet, anyway. But the good deal comes. A lot of those leases said, hey, if you only drill down to the Marcellus and this lease 5 years expires or 10 years expire, then everything below the Marcellus is returned back to me. So, again, just happens to be Tioga County landowners. If you're held only down to the Marcellus and you are completely free, you own all your gas rights to deeper formations such as the Utica, you need to understand the oil and gas conservation law, the critical points to it. And a good attorney is going to understand this and advise you and guide you in what your options are. But don't think, my opinion, general information, I would not think, if I had my Utica Shale rights, I would see them as very, very valuable because, first off, that's where a lot of companies want to produce from. So essentially, in my opinion, you are unleased because you are unleased to the Utica with regard to the Utica Shale formation. But also, the company needs you, or they may have to contend with these very difficult procedures, costly, expensive, unknown procedures of the oil and gas conservation law. So they want to lease you, but they're not going to tell you about that. They're just going to act like, well, we have these other rights, so therefore you're hardly giving us anything. No. In some cases, they may not even produce in the Marcellus. They want a Utica, so it's like you're unleased. This is Attorney Doug Clark of the Clark Law Firm. You're listening to All Things Marcellus, where you can join me every Sunday, 8 to 9 a.m. on this station. And if you missed any of today's show, go back to pagasleaseattorney.com, pipelineattorney.com. You can check out this show and many, many others. Been doing the show since when? 2010. Okay, so I'm going to do a quick general recap. Marcellus Shale Formation. If a company is developing from the Marcellus Shale Formation and you are not leased, they are not allowed to drill underneath you. They can't do it. They can't do it without your permission. But they can drill around you, and you would not receive royalties if you weren't leased. So there, companies at the end will typically put on a hard squeeze and say, hey, look, we'll just not drill underneath you because we're not allowed. We'll drill around you and you won't get anything. So you better sign for whatever terms that we're going to give you, and you should thank us because we're super nice and we don't need to do this anyway. We're just doing it because we're nice guys. So that's one thing that you can hear with the Marcellus. And the part about them drilling and all of those things are true. The nice part I'll leave to you. But seriously, in the Marcellus, cannot drill underneath you, but can go around you, and they don't need to lease you. But the Utica Formation has a special set of laws called the Oil and Gas Conservation Law Act, and it applies to the Utica, but not the Marcellus. So there, and I'll tell you this flat out, you're not leased. The company can't go drilling a well right beside your property. Can't do it because they need to then, if that's the case with Utica, they have to follow the law of the oil and gas law, the Oil and Gas Conservation Act. They have to follow that. And it's different. It's different. And they don't want you to know that. They don't want you to know, hey, we have a problem. Think about it. Why is a guy with 2 acres who's all the way at the end of a unit, who will never, ever see a well beneath his property under this setup of drilling? Won't see it. Utica Shale, he gets $3,500 and 18% offer to him for 2 acres. And plus, sir, we won't touch your property. We just want you to sign because we're really nice guys and we want to get you this money. Well, no, because you want to drill a Utica well. And if this gentleman doesn't sign, you're going to have to kick in the process of the Oil and Gas Conservation Act, and that's going to be super expensive. So, and you don't even know what the heck is going to happen. And we're going to talk. Don't leave me, because the last segment, we're going to actually get into some language. And again, this is an unknown area, so we don't know what's going to happen. But a big question is, if this gentleman who has 2 acres is in this Utica Shale area and he doesn't sign, the company has to go through a procedure where ultimately agencies, or maybe it's the DEP, or maybe it's the Environmental Hearing Board, we don't maybe even know yet, but some governmental agency for the Commonwealth of Pennsylvania, if they grant the company's request to drill, they will include that 2-acre property into a unit for Utica Shale development, even if that landowner did not sign a lease. But you should ask yourself, well, geez, if you didn't sign a lease, do you get a bonus? Do you get a royalty percentage? How are your royalties calculated? Well, we're going to talk about that in the next segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call, 570-307-0702. Before you sign any document, learn your rights, get a review and consultation, learn your rights. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump right in. We got a short segment here. So, okay, Utica Shale. Areas of Utica Shale development, super important to you. The Oil and Gas Conservation Law. So, okay, let me give you a little summary again. Not specific advice for anybody, but here's the deal. Utica Shale Law. If you do not sign a lease and the company is going to drill, and this is going to be just general stuff, so it's easier to follow. They're going to drill in close proximity to your property. So that well, that horizontal well in the Utica Shale formation is anticipated to extract gas from your property. Not underneath, it's not drilled underneath your property, but gas from your property will migrate to this well, and it's going to be your gas. So in the Utica Shale, they can go ahead, the company can lease you, create a unit, and it'll operate just like the way the Marcellus Shale development has been operating. However, if you do not lease, that becomes a different circumstance for the company. And so then, if the company wants to drill a well and it's going to be in close proximity to your property, let's use my guy who has 2 acres. And in this case, the well, though not underneath his property, is probably in an area where it's going to be having gas extracted from it. So the company really wants to lease them, or him. Why? Because they do not want to contend with the process of the Oil and Gas Conservation Law. I'm going to read a little bit and try not to make this too incredibly complicated because there's a lot to this act. So what I want to stress here is, so if they have, this is Section 8, Integration of Interest in Spacing Wells. If you want to look it up, Oil and Gas Conservation Law. So what it's saying here is that and I'm going to summarize so this is going to be easier to follow. Again, if there's a voluntary unit or voluntary integration, meaning pulling properties together voluntarily to develop them, we're going to see generally development like you would in the Marcellus. That's why companies want to lease you and lease your Utica rights. They do not want to deal with this next part. Here we go. In the absence of voluntary integration, that means essentially in the absence of you having a lease with a landowner that says that you're allowed to pull or unitize or integrate these properties to develop them together, this is back to the law, the commission upon application of any operator, meaning gas company who's going to drill, having an interest in this spacing unit shall make an order. So the commission shall make an order integrating all tracts or interests in the spacing unit. Integrating, meaning including them, meaning some people would say, like me, force you into this spacing unit for the development and operation thereof and for the sharing of production therefrom. Meaning, you could be forced into this Utica Shell unit and you would get royalties. Now, I'm only reading one section. Remember, there's a whole process to get to this point that the companies don't want to do. But so we want to get this before the show's over. So then, it says, next sentence, the commission, as part of an order, their order establishing a spacing unit or units, shall prescribe the terms and conditions. So the commission, not the gas company, not your agreement on the lease, the commission shall prescribe, if they're going to force you into the unit, they shall prescribe the terms and conditions upon which the royalty interests in the unit or units shall, in the absence of a voluntary agreement, meaning in the absence of a lease, that the commission shall prescribe the terms and conditions upon which the royalty interests in this unit or units shall be deemed to be integrated, meaning added here into this unit, shall be deemed to be integrated without the necessity of a subsequent separate order integrating the royalty interest. Now look, that gets very confusing. Let's not focus on that. Let's go to this next sentence though. Next sentence. So what it's saying there, just quick summary. If you're not leased, there's no voluntary agreement, then the commission will do this order and it will, as part of the order, deemed to be integrated. So integrate, force, pull you into this unit. But then it goes on. Each such integration order, or say a order to force you into a unit, forced pulling, each such integration order shall, this is it, this is also very important. Each such integration order, remember that's the commission issuing an order saying your property has to be in this unit. But that just doesn't happen overnight. There's hearings, there's a whole process to this. So each such integration order shall be upon terms and conditions that are just and reasonable. So if you're going to get forced in, it's going to have to be on forced, or it's going to be on terms and conditions that are just and reasonable. Goes on to state, and shall be made only after a public hearing, after notice, by certified mail to all other operators, because other companies may have leases on properties located within this area. So that they then have to notify all the landowners and any other company that holds an interest in properties within the area that this well is going to develop. So you have a public hearing after certified mail notice to all other operators or royalty owners within the unit whose interest is on record. So they have to notify all of the people who are within this unit or proposed unit area. Again, I'm not talking about the process to even get here. That's a big process. It's such a process that no company has ever yet done it. No one has ever yet done it. So they're really motivated to have you sign a lease. So you are voluntarily, because of your lease, placed into a unit, integrated into the unit. But if you don't sign, This is involuntary integration. But the company has to pay you just and reasonable royalties, bonus, whatever it's going to be. And it's going to be after a hearing, public hearing. Now we're going to talk about, do you get into arguments? How much gas is going to be produced? Should I be getting 20%, 25%? I didn't want to do this. Wow. There's a lot of interesting stuff that can happen, and there's no doubt, no wonder why the companies want to avoid this for many, many different reasons. We got to know this. I'm going to talk more about this. I really am. I'm up against it. Just know, oil and gas conservation law, Utica Shale development, you have possibly much more leverage, but we got to look at your situation individually. Somebody's got to tell you guys about it. Somebody has to get this out there, and it's not going to be the companies. All right, we'll leave you with our classic and our standard because it is so important. Number 1, stop signing bad agreements. Stop signing bad agreements. Pick up the phone and get information. Number 2, remember, do not rely on the gas company, pipeline company, landman. They work for the company, not you, the landowner. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Have a great week, everyone.